All right, the Supreme Court of Law South Session, Honorable Chief Justice Robert J. Torrey presiding.
Good morning. You may be seated. Welcome back, Ms. Tenorio. Welcome, Mr. Huseman. Good to see you here today. Will the clerk please call the case?
This is Supreme Court case number CRA25-004. People of Guam Plaintiff Appellee versus Franklin Chargaloff Taitague Jr., Defendant Appellant. Appearing for the Defendant Appellant is Attorney Braddock J. Huseman. Appearing for the Plaintiff Appellee is Attorney Christine Santos Tenorio. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Huseman reserves 10 minutes.
You may proceed, Mr. Huseman.
Morning, Your Honors. Before beginning my argument today, I would just like to say that I deeply regret my absence yesterday. The panel members, the clerk of court, the law clerks, and the staff were here. I was not. I regret my absence. I regret the waste of judicial resources, and I am sorry for the absence. I would also like to apologize to Ms. Tenorio and for the inconvenience it caused her, and I'd like to apologize to my client as well.
Thank you for that, Mr. Huseman.
With that out of the way, good morning. May it please the court. With my time today, I'd like to discuss two issues. First is juror misconduct by two members of the jury, and the second is ineffective assistance of trial counsel and failing to call a witness. I'd like to discuss the juror misconduct first. During voir dire, the trial court asked a question of the panel members: have you ever been a victim of a crime, and will this affect your ability to be fair and impartial? There are two jurors at issue in this case. Juror 4 said no, even though that juror just months before had been the victim of a domestic assault and admitted later that the assault had been traumatic for her. Juror 8 was also the victim of an aggravated assault, relatively recent in time, but not as close. When this became known to trial counsel, there was a request for a mistrial. Courts analyzed that under the McDonough test. This is a two-pronged test. Did the juror fail to answer honestly? And would a correct answer be grounds for challenge? And part of the reason we're here today is the trial court erred on both steps or both prongs of this test. So here we think the court found that neither juror 4 nor juror 8 were dishonest, and we think there's clear error in that factual determination. And part of the reason—
Did you say that they were dishonest, or?
Yes, I think they were dishonest. And the reason we think they were dishonest is due to the fact that the juror 4 knew, I think knew that she'd been a victim of crime. I think there's evidence in the record that she knew she was a victim of crime. She called the police after the incident. Generally, people don't call the police unless they feel like they've been a victim of a crime. And part of the reason we think there's clear error here in the court's factual finding is because the court changed the test. Not the test. The court changed its instruction to, or its question to the jury. So when the court asked, have you ever been the victim of a crime? The court excused the failure to say yes because it made the distinction that the jurors didn't know that this was a quote unquote charged crime. But that isn't what the question, that isn't what the court asked. The court asked if they were victims of crime. This might be excusable if, as an example, I think this has happened to me, where I think I leave my car unlocked in a parking lot. The next morning I go to the parking lot, I open the door, and it's clear that my car has been rooted through and things have been taken from it. I am technically a victim of a crime. I do not call the police. It's my fault. I made that error.
I thought the issue more on that was that It was the compound question as to whether or not the juror could remain fair and impartial.
Well, and I think part of the problem here is it is a compound question, but they're dependent, and the court treated those as independent. So the question is, have you been the victim of a crime, and will that affect your impartiality? And part of the problem here is when the court focused on the second part of that test and ignored the first part. So the second part of the test is, can you be impartial? Well, and this is the other reason we think the court clearly erred here in these fact findings, is because I don't believe it's possible that the trial court actually thought that's the correct approach either. Because if the court believes this compound question relieves the first part of that question, have you been the victim of a crime? And the only relevant question is, can you be fair and impartial? Well, then the only question that ever needs to be asked at a voir dire is, can you be fair and impartial? They can be very, very fast voir dires. The juries will pick themselves. Do the jurors believe that they can be fair and impartial? If the answer subjectively by the juror is yes, then the juror can sit. And the problem with that is that's not how this court went forward with its voir dire, because that isn't the standard. The jurors do not pick themselves. The jury selection is generally within the province of the trial court with the assistance of the parties, so that a fair and impartial juror can.
So are you suggesting that simply by being a victim of a crime, that in and of itself is sufficient to show actual bias?
No, Your Honor. And this is also part of the problem with the test. If the court, when the trial court bifurcated this test, McDonough court is to determine if there's a false statement. And then that false statement is then used to determine bias. All right. So, and that bias can either be inferred or direct. And so here, when the court skips that first part of the question, have you been the victim of a crime, it deprives this court of the ability to go back, review, and do any kind of review, because there's the question of bias is in that first part of the question. Have you been the victim of a crime? So back to my original, or not original, but my hypothetical, I am the victim of a crime if I leave my car open. But I don't believe that if I'm asked on a jury pool, I didn't call the police, I didn't even really think about it. Am I technically incorrect if I'm asked if I'm a victim of a crime? No, I'm technically incorrect. Am I lying to the court? I don't think so. I don't consider myself a victim because I didn't call the police, because it's a minor infraction. Here, though, we have a situation where the individual, and let's focus on juror 4 for the moment. Juror 4 is victim of a crime, victim of abuse, within 8 months, calls the police. It strains credulity to argue that she didn't really know she was the victim of the crime. Again, she wouldn't have called the police if she didn't think she was the victim of the crime. And that therein is the problem. And because the crime is similar to the one at issue here, right? We have a abuse by a family member or a domestic partner, in her case, family member in this case.
But I thought the analysis of the trial court is, and I understand that the thinking of the juror number 4 may have been, have you been a victim of a crime? And although she may have thought that yes, she was a victim of crime for the reason that you said, and she reported it, and she was the victim of a domestic assault. But I, as the Chief Justice mentioned, I think it's the compound question. And if you've been a victim of crime and you've conceded that in and of itself is not sufficient to establish bias, but I can still be fair and impartial. And the trial judge, in an abuse of discretion standard of review, in terms of observing the demeanor of the witnesses, has determined that it was a mistake on her part, and he didn't determine that she was being dishonest. So why is that not an abuse of discretion?
Okay, so, and what I would point to here is the error in the error in how the court reached its opinion as to that she wasn't dishonest. So, as I mentioned, the court changed its question, right? So, I don't believe that
Change it in what way?
the question was, have you been a victim of a crime? And the opinion is she didn't know she was the victim of a charged crime. And so if this court were to look at similar in a civil context, where it's reviewing a judgment by a trial court that says that has a contract in front of it, and the judge changed one of the defined terms within the contract to reach that judge's decision, I don't think there's any dispute that well, we can all agree that would be a problem because the judge is changing the definition of what the parties had agreed to. That's not very different than what happened here. What happened here is the judge asked, are you the victim of a crime? And then the witness says, well, I didn't know if it had been charged. And the judge is like, well, she didn't know she was the victim of a charged crime, so not a problem here. My argument and my client's argument is that that kind of buttressing does not belong here. The judge is, and I understand there's pressure here. This has already been a mistrial once. The judge is worried about use of judicial resources. He's trying to keep this trial together, but Mr. Taitague has rights. Those rights need to be protected. And in this case, once the court is confronted with this problem of a witness saying, well, it wasn't a charged crime, so I didn't know. I think it was incumbent upon the court to satisfy itself that without making that kind of definition, because the actual response there isn't, well, okay, she said it wasn't a charged crime. So, well, I didn't say it was a charged crime. I asked you if you had been a victim of a crime. What happened here? And as a public policy matter, voir dire is perhaps, if not the most important part of a trial, is one of the more important parts of the trial. I think we can all agree on that. And
Let's assume for purposes of your argument that the juror failed to honestly answer the question. How would the truthful response have provided a valid basis for challenge for cause?
so a truthful response here, I think, does provide balance for a change of cause just on a strictly, Your Honor, she's the victim of a similar crime. This is a criminal sexual conduct case, but that's a domestic case. It's abuse by a loved one or a close family member. And because of that, we're asking the individual to be relieved from jury duty. Now, I think that is grounds, that is cause to dismiss it. That doesn't necessarily mean the trial court would have dismissed it, but that's not part of the McDonough test. The McDonough test is just, is there bias? Or
I thought the
is there
second prong of McDonough asked whether a truthful response would have provided a valid basis for challenge for cause.
And that is my answer. And then I think this is a valid challenge. I don't think it has to be a successful challenge. A valid challenge is all that is required. And that's because by the time we're exercising McDonough, we're looking at McDonough, the cake is baked. And the case law is clear. Even one juror that on a panel that has an impartiality problem is a problem for a fair jury, and a new trial is required. So if the court does assume that this was an untruthful answer, or for the purposes of this, we're assuming that, then I think that there is a valid objection to that juror straight away because of the closeness of especially juror 4's crime that was committed against her.
But isn't the most important part that she feels she can be impartial?
I don't believe it is the most important part once there is this dishonesty that's a problem, because it calls the initial dishonest answer calls into question the other things and why these answers were given in the first place. which goes back to some of the problems with the trial court's findings. It didn't probe very hard on this, and we're left with a situation where, like I said, I think the court changed definitions, changed the question, and made it, and buttressed the jurors' response to get to the point where they could say, or where the court could say that the fair and impartial is the important part.
But following up on Justice Carbolito's question that, whether jurors should be disqualified solely for having experienced or been a victim of a crime, doesn't seem to be the proper test, right?
No, and I don't think that is the proper test.
Okay.
So just because you're committed a crime, then that's where the bias comes in, right? There has to be a questioning of, is this direct bias? So direct bias is something obvious like, I hate all cops, right? So the juror says that they hate all cops, and can that be cured? In this case, if you were talking about a juror who harbored that belief and put it all over social media, but was asked a juror's question about how they feel about police officers, and police officers are fine. And then it comes out later that they, in fact, social media'd everything saying how much they hated the police officer, right? Then there's a question here of direct bias, and a court can use that to run the McDonough test. But this is, again, after that cake has been baked. Indirect bias is more a situation where I think it's closer to this case, where because of the closeness of the crime, because of the closeness of the allegations and the similarities, that there is a presumed bias in cases like this that are extreme. But there's also, like I said, I think there's a possibility here that this was direct bias as well, and that the answer is false. And then the question becomes, why is this answer false? And that isn't really explored in the record.
This is an abusive discretion standard, and the judge made factual findings, essentially that she was not an impartial, she would be an impartial juror. Don't we trust the judge's experience in determining credibility, not only of witnesses, but other people that are asked questions in court?
As a general rule, yes, Your Honor. That is something that is left to the trial court, and part of the reason we're asking you not to leave it in the trial court's hands in this time is because of the things like the change test, or not the change test, the change question, the changing definition. Are you the victim of crime? Well, she's not the victim of a charged crime, so that's why that error was made. But as soon as the judge starts tinkering with the actual definition and the actual question the judge asked months before, that becomes a problem. And I don't believe it becomes a problem for this court and for obviously Mr. Taitague, but I think the court's response when the trial court makes an error like that and basically changes the question that it asked, this court is right to say, well, there was no reason to change the question. The duty of the court then is to dig deeper and figure out what actually happened. And so the deference there is used up by the change in the definition from crime to charged crime, is my answer. Does that answer your question?
Generally, I suppose, but you can tell usually when a victim really has been affected by the crime. They're very scared to be a juror, they're shaking or crying. It doesn't appear from the record that was the case here. So I think the judge's determination she was impartial could be respected.
And our disagreement then would be on the fact that if the judge had just issued that opinion, like I believe this was an error, the juror didn't understand. It's when the judge starts making excuses for the juror and that we have a problem with that.
For juror 8, I mean, even under your example of the unlocked car, I mean, he didn't believe he was a victim of a crime. He seemed to render assistance to someone who was, and then left. And even though the guy followed him, he didn't view himself as a victim. I mean, why was that a dishonest assessment of the situation?
Well, and in that case, which isn't nearly as close as juror 4, and I would concede that. We think both are enough, but certainly, in this case, juror 4 is closer. Juror 8, didn't require the court to change any definitions. I would concede that. This court still did make the same determination, charged crime versus not charged crime. But, I would accept if the court, I guess this runs two ways. If the court were extremely concerned about juror 8, then juror 4 is, I think, a slam dunk. If the court is not extremely concerned about juror 8, using your hypothetical or your question, then I think juror 4 is still viable. It's much closer type of crime. And so I would concede the court's point that they aren't very similar about 8, and that also goes to bias. But I still think it's enough. But definitely, juror 4 is a much closer analogy. And Mr. Taitague only needs 1 juror, not 2. We brought both those to the court's attention. With already over, but I just want to hit ineffective assistance of counsel real quick before I yield the remainder of my time. Courts define ineffective assistance of counsel as a deficient performance that results in an unfair trial. The failure to call a witness is deficient performance if there's not a reasonable tactical decision behind that failure to call the witness. In this case, there was a witness, Ms. Mantinonia, who was at many of these family gatherings, and these family gatherings are where the jury found that after them that there were weekly assaults. Ms. Mantinonia could have directly testified as to Mr. Taitague's whereabouts at the end of those parties and how the parties had moved. Trial counsel tried to get that testimony out obliquely through other witnesses and failed to call. Ms. Mantinonia would have been direct testimony on this issue, much more powerful. And we think that he was denied a fair trial because of that. And if there are no questions on that issue.
Just on that point, I mean, it goes to the weight of the evidence, and in reference to what the jury heard the attempted or apparent alibi defense and through other witnesses, although as you may argue, it may not be as it may not be as strong as having potentially Ms. Mantinonia testify. Again, in terms of the standard of review and the prejudice, the second prong of the Strickland test, the jury heard what was trying to be conveyed. It may have not been as forceful, but I don't know necessarily if that's a test, whether or not the most forceful way of presenting the evidence is what is required.
No, I would say it's not whether it's forceful or not. It's whether there was a tactical decision that was reasonable not to call the forceful witness in the first place. And to the extent that, and we put this in the briefing, to the extent that some of this would be shrouded in attorney-client discussions, we would ask for the ability to, for this issue not to be foreclosed in a writ proceeding. But to go to your question, Your Honor, I don't think whether it was more forceful is the answer. The question really is more whether or not there was a tactical decision based on reasonable investigation. And here it does not appear that there was.
But what was the prejudice to your client?
Well, the prejudice is it is more forceful to have the evidence presented directly and forcefully, and I understand that that's not the test, but that is the harm that fell to my client. I'm over, so if there are no other questions, I will reserve the remainder of my time.
Thank you, Mr. Huesman. Ms. Tenorio?
Thank you. Mr. Chief Justice, may it please the court. Mr. Taitague received a fair trial in this case with an unbiased jury, and he received effective assistance of counsel, as evidenced by the fact that though he was convicted of 3 counts of criminal sexual conduct, the jury weighed the evidence and acquitted him of 1 count, suggesting that they were impartial and could fairly weigh the evidence, notwithstanding their life experiences. Now, the trial court denied the motion for new trial, which this court reviews for abuse of discretion. The trial court was within its discretion to do so. Based on the McDonough test, under the first prong, the trial court found that there were no dishonest answers by the jurors. The jurors in question are jurors number 4 and 8. I'll take them each at a time. Now, juror number 4, she was given a compound question. Have you been a victim? And if so, can you still be fair and impartial? The trial court emphasized that this was a 2-part question. And the trial courts normally do this, and not in this court or in this particular trial, but it's normally explained as, even if you're a victim, don't answer unless you have a complete answer to the 2-part question. So I say that because that illustrates that lay people and veneermen receive questions differently. They interpret questions differently. So when the trial court asked this juror's taking it as the 2-part question, and she believes that she can be fair and impartial. We asked her.
But then why not just ask fair and impartial and forget about the first part, if that's all that's important?
So to answer your question, it's important to delineate the first part because it is still gives the defense or the counsels the ability to further voir dire on that issue, which in this case, that's what you can do. And the reason I will illustrate this. Normally that's in the trial court's script of questions. As a prosecutor, I normally follow up later with this means charged versus charged and uncharged. So whether or not you have been a victim of a charged crime, we need you to answer the question. So even though the trial court transcript contains this, that doesn't stop the counsels from ferreting that out on voir dire. With juror number 4, she actually did answer a question that she was involved in child support proceedings. That could have also led defense counsel to further voir dire on that because clearly the AG's office would also be involved in that, and that could have ferreted out some things, but the defense counsel failed to do that. So in this case, and as in all trial court, the jury selection process, the focus is on impartiality. So that is why the court poses that question. Now, since the appeals have been coming up regarding this issue, I have asked the trial courts to ask it in a disjunctive manner and ask it one by one so that we don't have this issue and that all counsels can know whether or not people have been victims of a crime. But also, every prosecution and defense counsel, they have access to resources and the trial court resources where they can actually look up their jurors, which is a practice that you're normally supposed to do to make sure that you're not missing something and to ferret out whether they are a defendant or a victim of a crime. So in juror number 4's case, this was not discovered until the jury was in the middle of deliberations. Then it came up because if there was an issue, and she explained the reasons why she didn't answer the question. So the trial court was able to observe her demeanor during that portion of the process. And then later, when we had the evidentiary hearing later, he was also able to determine her demeanor. And if you look at what the transcript of juror number 4, she even actually, during the, when she was being voir dire in the middle of the jury deliberation, she actually says, may I say something? You know, even if I misunderstood the question, something to the effect of, even if I didn't answer those questions or misunderstood, I can still be impartial. This is not going to affect my sitting as a juror in this case. And while defense counsel tries to say that her life experience is similar to that of the victim in this case, it actually is quite distinct. Being a domestic violence victim of your partner is a very different life experience than being sexually abused by a close relative who is in actually a position of authority over you for the course of several years. So there is Turning to the second part of the test, about whether there would be a valid basis for cause, even if that it had come out during the jury selection process that that was her life experience, it would not have been a valid basis to challenge her for cause. Now,
Can't that give rise to a preemptory challenge that the defense didn't have here?
correct, it could have. It could have risen to a peremptory challenge, but I believe I cited case law from Washington Supreme Court where they've said that's not the test for under McDonough. You actually have to prove that you could have stricken for cause, not that you would have had a valid peremptory cause, peremptory challenge. Now, in this case, in his reply brief, defense tried to say that the test is whether you have a valid basis, not whether it would have been granted. The courts disagree with that notion. If you look at the Fourth Circuit, they say that the defense has the burden of saying that that challenge for cause would have been granted. Another circuit, I believe was First Circuit, says that the challenge for cause portion of the test has to have precipitated the trial judge to believing that the juror lacked the capacity, indeed lacked the capacity to be a juror. So this, the defense would not have had a valid basis for cause for juror number 4 on the basis of she was a charged victim of a crime. And as the defense has conceded, there is no law there is no law that says simply by being a named or unnamed victim of a crime, that excludes you from jury duty. So I want to talk about actual bias versus implied
Before you
bias.
do that, it's difficult for me to grasp in terms of how you've modified what counsel has said that the test is, and that it's defense counsel's burden to show that the motion would have been granted. And that is that not only was there a valid reason for the challenge, but that the challenge would have been successful. It's difficult for me to how you're going to be able to show that. I mean, if you have 10 different judges, I don't think it's going to be 100% that they'll be unanimous hearing this evidence that they would have granted it. I think the more reasonable basis is that the reasons expressed constitute a valid ground for challenge for cause.
And to answer that question, Your Honor, I would say the test revolves around partiality. And so you cannot obtain a new trial unless you can show that there was actual bias on the part of the jury under the McDonough test specifically. So what that is different from saying that you would have had a valid challenge for cause versus you proving
I
it.
thought it was actual or inferred.
So that's why I want to talk about actual versus implied. So the circuit courts are kind of treating it in separate from each other. So the Ninth Circuit actually treats actual versus implied bias as a separate test from McDonough. So does, I believe, 10th Circuit. Some of the other circuit courts treat actual versus implied bias under the second prong for the reasons that I have stated, because it's supposed to focus on partiality. Now, so for the actual versus implied bias, treating that as a separate test, the appellant fails under both. So the trial court's findings, the trial court actually stated that it would not have been a valid challenge for cause. That was in the trial court's decision and order, which we give deference to. A finding of implied bias is reviewed de novo. This is separate and apart from the traditional McDonough test, because a defendant can still say he did not have a fair and impartial jury based on actual versus implied bias. The point being that in this case, the defendant cannot prove either. There is no actual bias because we have a juror number 4 repeatedly saying throughout the transcript that she can be fair and impartial, and the trial court agreeing that she could be fair and impartial. For implied bias, that's reserved in such exceptional and rare circumstances that do not apply here. So the Supreme Court, just so to give an example of implied bias, because that's actually what defense counsel brings up. He says it is difficult to prove actual bias, so he focuses on implied bias in this case. An implied bias, though, does not mean that you would have had a valid challenge for cause. I'm trying to distinguish the two. Sometimes people conflate it, and so he said that I conflated it, but that's because some circuits collapse the test. But I'm arguing separate and apart, he cannot meet the test. The Supreme Court has noted, the United States Supreme Court has noted that implied bias is found in situations where you're an employee of the prosecuting agency, whether you're a relative of a trial participant or a part of the transaction, or if you're a witness to the crime. The Ninth Circuit has said implied bias is when you have an identical experience, if you're aware of information by the defendant that would be prejudicial, and if you lie to secure your spot on the jury. So none of those examples are present here. Juror number 4's situation was so attenuated that it's not, she did not have the same life experience as this juror. If this was a situation where she was a criminal sexual conduct victim, and that question is specifically asked normally, we would be in a different, we'd be having a different conversation. But the point being, if under the second prong of McDonough or actual versus implied bias analysis, they cannot show that the juror number 4 was actually biased or impliedly biased based on her answers. Now, when Mr. Huseman says, well, the trial court should not be given deference because he changed the test, I don't think that that is what occurred. The trial court's discussion of whether being a victim of a charged crime was made in the context of trying to contextualize why juror number 4 would have not responded. So I don't think he changed the test. He was actually doing that to make the analysis on the first part of McDonough that jurors' answers have to be dishonest and not merely mistaken. And in this case, she wasn't dishonest because she answered the two-part test question correctly, because she said she couldn't be fair and impartial. Now, turning to juror number 8, juror number 8 is, so I'm a little bit confused about why juror number 8 is at issue, because one, juror number 8, they didn't make an issue of that until after the trial, when the motion for new trial was filed. But even at that, during the motion hearings, defense counsel conceded that either side would have had a valid challenge for cause because his sister was an employee of the public defender, and then also because he was a named victim in a criminal case. So I'm not sure how one could argue that you could have had a valid challenge for cause if those situations cut against each other and cancel each other out. For juror number 8, juror number 8's responses during the evidentiary hearing are evidence that jurors do not receive questions from the trial court the way maybe lawyers do. He said that even though the question was posed whether you have been a victim of a crime, he thought it was CSC crime because of the indictment that was written out. So he said, that's why I didn't raise my hand. Now for him, there is also a difference because it shows that he was a victim of a charged crime, but he didn't see himself like that, because sometimes when the attorney general were looking through charges to be lodged, we are looking for who is victimized, whether or not they think that. So he was a victim by virtue of the perpetrator chasing him down in the car because he had the victim that he found on the road. So for him, I think the trial court ruled that he was merely mistaken and not dishonest. And I think his answers really go to show that these jurors are not lying. They are receiving the question how they are interpreting it. And if I believe that at jury selection, the questions can be shored up so that we do not run into this situation. But any error on the part of trial court or defense counsels or prosecutors in posing the question should not be imputed to the juror because it's not their fault that the question was asked imperfectly. So for juror number 8, there would have been no challenge for cause. His case had already been closed. And he actually said, I didn't know it was a criminal case, even though the Attorney General's office was calling me. So when you talk about the trial court assessing for disingenuous, he didn't find any of that because these lay people are saying, hey, whether or not you call the police, you don't know that you're a charged victim of a crime. So that is further illustrated by, I believe I asked a question in jury selection where it says, who here's been a victim of a burglary or something like that. One person throughout the whole veneer raised their hand, and it's just going to show people are not thinking of themselves as victims. So that is a very important analysis when we talk about whether jurors are intentionally dishonest versus mistaken. Now, there was no ineffective assistance of counsel in this case because, well, one, he is clearly effective because there was an acquittal on the 2018 criminal sexual conduct charge. But two, this court has said on a habeas case that failure to call a witness is not automatically deficient performance on the part of a defense counsel. Here, while we don't know the strategy because that's not on the record, I think that the record is sufficient to show that the defendant was not prejudiced by the lack of calling the ex-girlfriend. And here's why. The evidence showed that the ex-girlfriend was not actually at the parties where the victim was being taken from. She would have been at home where it was not occurring. At the defendant's home. None of the acts had ever occurred in the defendant's home at the time that they were together. Some of the acts occurred before they were even together. So for all of those acts, though, the defense called, well, he didn't, I called him as a witness, but he elicited it through his cross-examination from the defendant's father, aunt, sister, and brother. 4 people testified to support the defense theory that it was impossible for the defendant to have committed these crimes because we would have seen it because the theory was that he was taking, well, the evidence showed that he was taking the victim from a family gathering that happened every Sunday and taking her away either to his dad's house or to the modular house next door. These areas are about 10 minutes, a 10-minute drive from each other. So if the jury heard from 4 people who were always at the Sunday gatherings that they never saw him taking the victim to the store, but they heard from her family members that actually he did take her to the store, then Ms. Mantonio's testimony would not have affected the verdict. Why would her testimony matter if she's not even at the family gathering that he had been taking her from? So he cannot show that any failure to call Ms. Mantonio was ineffective assistance, especially because I outlined the periods of time where Ms. Mantonio wasn't even on the island. So if she's not even on the island, you can't be an alibi witness because then you don't know what he was doing while you were absent from the island. So that factual determination was very clearly made by the jury because all the times in question, the defense witnesses had given him a sort of alibi for or an excuse for or a impossibility argument for, and that was all resolved in favor of the victim. And so in this case, I don't believe that they could show, I do believe that the record is sufficiently developed to that issue, but I don't believe that there was ineffective assistance of counsel. If there are no further questions, thank you.
Do you think there are any facts not in the record necessary for that determination?
I don't believe that because, and the reason why I don't is, one, she was off island and we know that that was in the record based on her letter from the pre-sentencing investigation report. And so I think that that is the fact to consider of why she did not testify, because she was not on island for any of the trials. And while Zoom testimony is available for only defense witnesses, yeah, that is what we have on the record as to the reason why she was not called. Thank you, Your Honors.
Thank you. Mr. Huseman, you have 6.5 minutes.
Thank you. So with my remaining time, I would just like to point out some of the problems here. So this case involves a lot of circular reasoning. The judge's bifurcation of these questions and the cure that the government and the trial court keep attempting to use is that the juror believes that they can be fair and impartial, and that cures everything that comes before it. When the court does that, when the government does that, and then the government concedes that this compound question is not necessarily being answered correctly by jurors, it's setting up a situation where the court is no longer in charge of a jury selection. The parties don't have much of a say in it either. This is really just whether the jurors think they can serve on a jury or not. And again, I don't think that's what any of the justices, or excuse me, any of the judges, the trial court judges believe. It's certainly not what the parties have come to expect from voir dire. The idea is that they get to pick a fair and impartial jury, and allowing a jury member to say that they're not a victim of a crime and then deprive the court and the parties the ability to determine if that is direct bias.
But isn't the burden of proof, at least in this particular circumstance, where it is that the defendant is challenging the impartiality or partiality of the juror, in this case, in more particular, juror number 4, that when the statement is made by the witness, I can be fair and impartial, and there are no other circumstances that may suggest otherwise, although we can't read into the minds of the jurors, that is what is left. And if the defendant is not able to point to other circumstances that may question that statement, then how is it that we're going to say that the judge abuses discretion?
And this is why we cited the inferred bias cases, where the Ninth Circuit, I think we put 3 of them in our cases, where they involve either a father lying about being the victim of a heroin crime when 2 of his sons were convicted, where a woman was said she was not a victim of a crime. 6 years prior, her husband had been murdered. And these are all instances of individuals trying to get on a jury. And the question becomes, why are they trying to get on a jury, and why are they being dishonest about the original question? And here, the way the court has set it up and the way the court has excused it, the trial court, is set up a situation where it skips this question of whether this is direct or indirect bias. What are you the victim of a crime? So we can figure this out. And then you just skip straight to the second part of the test, which is, can you be fair and impartial? And thus we're skipping the bias. We're skipping the way to even analyze this post facto under the McDonough test. We're whitewashing it, and that is a problem. Again, direct evidence of bias is more of the social media posts about, I can't stand the cops. Here, I think this is more inferred bias, which is the extraordinary situation where there has been a dishonesty about being involved in a crime.
But Ms. Tenorio seemed to have dispelled those circumstances in relation to, for example, the type of crimes that were experience and then one was that your client was convicted of.
Well, I understand that that is the government's position, that these people have very different life experiences. I don't know that that was in the record, and I don't know that that is in any kind of scientific journal that has been cited at the court. So I understand that that is Ms. Tenorio's life experience, and it's a fine argument, but I don't believe it has been dispelled. So I respectfully disagree with that characterization. It's outside the record. And what we're dealing with here is a individual who 8 months prior was the victim of a crime, called the police, and then told the judge, no, I've never been the victim of a crime. And the judge said, well, it's not a charged crime, so it's okay. And this is the problem the court is faced with. And we're asking the court to reverse the trial court's decision, grant him a new trial. And if there are no other questions, that's my argument.
All right. Thank you, Mr. Eastman. Thank you, Ms. Tenorio. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.